Okay, members, we will go ahead and reconvene. At this time, I will pass the chair to Vice Chair Burden so that I may present a bill.
Thank you, Chair. All right, members, we are on tab 1, which is Senate Bill 248 on medical negligence by Senator Yarborough. Senator Yarborough, we see you have a delete all amendment to the bill, so let's go straight to that delete all. Members, we're going to look at amendment barcode 932842. Senator Yarborough, you're recognized to explain the amendment.
Thank you, Madam Chair. Senators, like many of you at your local delegation meetings here at the Capitol and/or through phone calls and emails, I've learned about and listened to the stories of a number of individuals who were impacted by the wrongful death exception currently in Statute 768-21-8 that was enacted in 1990. In full respectful candor, let me be clear that the sole reason I have placed this issue in front of us is because while an effort to reduce medical malpractice insurance premiums at the time was a worthy pursuit, implementing a ban on certain individuals to where they could not and still cannot access their judicial system to plead their case is a clear injustice. If a decedent was past their 25th birthday, had no children under the age of 25, and was not married, no one may bring an action alleging medical negligence. I am unaware of a way for us to know how many legitimate claims of medical negligence might have existed over the past 34 years since this exception was made law, but I am confident that with a population like Florida's, undoubtedly in that time frame, legitimate issues of negligence are bound to have existed. For this reason, I put before the committee today a repeal of 768-21-8 in order to provide access for those who do not have it today, but because efforts over the last several years to do a clean repeal of the subsection have not garnered enough support to pass the legislature, I knew we would need to find a way to thread the needle and strike a balance if we hope to help impacted individuals. Arguably, repealing the subsection could likely result in higher insurance premiums. To offset this impact and also to afford all of our constituents the opportunity to benefit from lower health care costs, I am also proposing that we add caps on non-economic damages if a claim relates to wrongful death stemming from medical negligence or personal injury stemming from medical negligence. As I put forward in the whereas clauses and findings, Florida has the highest medical malpractice insurance premiums in the nation. We also have a rapidly growing population and changing demographics that dictate the need to have a legal environment favorable to attracting and retaining physicians, especially our high-risk physicians. While not an official part of President Pasadomo's and Senator Burton's excellent Live Healthy initiative, this effort comes favorably alongside and runs parallel. While the imposition of non-economic damage caps enacted in 2003 were subsequently struck down by the Florida Supreme Court in 2014 and 2017, the amendment contains a cure for the primary issue upon which the court took issue, which was equal protection. The court opined that multiple claimants would not be entitled to recovery of damages up to the cap amounts. Also, some claimants could receive higher awards based on severity of injury while others could not. To fix the court's concern, this amendment moves from aggregate caps to per claimant caps and also removes the categorical distinctions to ensure all claimants can receive a full award of damages up to the caps. With all of that as background, here are the specifics included in the amendment before you today, barcode 932842. The amendment again repeals the wrongful death exception. It removes the probable cause process contemplated in the filed version of Senate Bill 248, adds caps on non-economic damages for medical negligence-related wrongful death and medical negligence-related personal injury claims of $500,000 for practitioners and $750,000 for non-practitioners. And as a side note for clarity, the amendment does not include any caps or limitations on economic damages, i.e. for medical expenses, funeral expenses, lost wages, or the like, so a jury in court would not be limited to making such awards at levels they deem reasonable. Replaces aggregate damage caps with per claimant caps, removes the categorical differences based on type of injury, thus treating all damage claims equally. It requires medical malpractice insurers to include in their rate filings with the Office of Insurance Regulation information related to projected changes in claim frequency, claim severity, and loss adjustment expenses. Also, OIR must ensure the rates for coverage account for this legislation. It requires the Office of Program Policy Analysis and Government Accountability, or OPAGA, to study the statutory caps and evaluate the availability, affordability, and volatility of professional liability insurance coverage for medical negligence, plus the per capita supply of licensed physicians in the state. OPAGA must issue a report to legislative leaders and the governor by December 31st, 2029, which includes in its findings and recommendations whether the caps on non-economic damages should be retained, modified, or eliminated. Lastly, the amendment includes findings to support the legislation and has an effective date of July 1st, 2024, plus clear language, that it only applies to claims that accrue on or after July 1st, 2024. Madam Chair, that is the amendment.
Thank you, Senator Yarborough. Senators, we have a late filed amendment to Senator Yarborough's amendment. And to put us in the proper posture, seeing no objection, we'll take up late filed amendment barcode 651228 by Senator Book. And Senator Book, you're recognized to explain the amendment to the amendment.
Thank you very much, Madam Chair. And before I get into the substance of the amendment, I just want to thank the chair for his hard work, for everyone in the room to try to keep everybody calm. I think that this is a chair who knows every single one of your family members. He cares about every single one of you and the work that you have put in, and really does. And so I just want to first, before I even get into the substance of the amendment, thank him for that, because when he's here at 9 or 10 o'clock at night working through these issues, he really is. And I see the family members nodding their head, and I know that they know that. And so, Mr. Chair, I think that speaks to who and what you are in this process. So I first wanted to put that on the record and say that. And so thank you. And I know you and I have talked a lot about this process, and I want to thank you and your staff for all of your hard work on this bill over the past year. And I know that we've continued to work through it. And while I understand that your amendment aims to allow these families access to the courts without opening up the hospitals and doctors to an extreme level of liability, I have a hard time putting a dollar amount on the pain and suffering felt by some of these families. And you and I have talked a little bit about that. So my amendment would simply repeal subsection 8 of the statute, and without imposing any of the caps on economic damages. I'm not sure that trading one injustice and limiting another is the right way to go. So that is my amendment, Madam Chair.
Thank you, Senator Book. Do we have any questions on the amendment to the amendment? Senator Harrell?
Thank you. Just to be sure, I want to make sure I'm understanding exactly what you're doing. You are removing the whole aspect of the bill that reinstitutes and readdresses the issue of caps. All non-economic caps would be eliminated under your amendment. Is that correct?
Senator Book?
Yes, Madam. Yes.
Thank you. Additional questions? We have a few appearance cards on, this is on the amendment to the amendment. We have many appearance cards on this issue today, so these are for the amendment to the amendment, so that's the point Senator Book just made. Eric Tinsman. Is Mr. Tinsman here, who will be followed by Andrew Bolin, and I'm going to ask you, just because there's so many and you may be up later, please keep your comments as brief as you possibly can.
I will. Thank you very much.
You're recognized.
Senator Book, Chairman Yarborough, thank you for having us here. Senator Book, thank you very much for this amendment. My name is Eric Tinsman. I'm here on behalf of the FJA. I think if everyone in here had to list the number one thing they wanted to accomplish today in this committee, maybe not everybody, but most people would say if they had to pick one thing, it's to get rid of this med-mal wrongful death exception. We disagree after that, but everyone here, most people here, want to get rid of that. This amendment by Senator Book does that. So thank you, Senator Book. I have been in the position as a medical malpractice trial lawyer to get these calls. It is heartbreaking to have a client call, have a client say, I'm 55 years old, my son is 28, he went for a routine procedure, he didn't come out. And I sit there and I wait to hear their entire story because I want them to have an opportunity to explain themselves. And at the end, you have to tell them there's no case. You cannot do this in this state. There's an exception for an adult child who's over 25. There's nothing you can do. And with Senator Book's amendment, we are able to do that. I thank you very much for that. I thank you for your time, and God bless.
Thank you. Andrew Bolin, who will be followed by Belinda Warren. Mr. Bolin, you recognized?
Thank you very much. Andy Bolin on behalf of the Florida Justice Reform Institute. I am a medical malpractice defense attorney, and I represent Florida's healthcare providers all over the state in medical malpractice litigation. I'm here today in opposition, respectfully, of the Amendment 651-228 because...
Excuse me, Mr. Boland, we're on the amendment to the amendment? That's the one you're speaking to? I'm just making sure I'm in the right place with you. Okay,
Yes, ma'am.
thank you.
Yes, ma'am. So I'm in opposition to the amendment on the amendment because it eliminates the protections that are written in to the amendment by Senator Yarborough. If we are going to expand the universe of claimants in the state of Florida, there must be some countermeasure, some counterbalance that is going to provide fairness and balance in the civil justice system. There's no way for us to know exactly how many of these claims are out there. We certainly hear for several years, we've talked about this subject. We've heard from from proponents of the bill and the fact that they turn away these cases regularly. I've done media appearance here recently where I believe it's the largest plaintiffs firm in Florida said that they turn away several of these cases per week. So we know there are hundreds of these cases, if not thousands of them, that are going to be filed each and every year. So if we are going to remove that prohibition, then we also must have some counterbalance in the system. And so that's why I'm opposed to the amendment. Thank you.
Thank you. Belinda Warren, who will be followed by Sarah Franqui, and if I mispronounce anybody's name today, I'm just going to apologize right now. You are recognized. Again, we're on the, just to clarify, we're on the amendment to the amendment right now. You're recognized.
Yes, madam. First, I would like to ask that each of you have received this in email. Each of you should have received an email entitled Dear Senators. Have each of you received that in your email?
Ma'am, you're here to make comments on the amendment.
Okay.
To the amendment, not testify
What I
on the
wanted to
question.
say is that, you said Florida was the top one with malpractice. And here I have found many things that prove that this not to be true. New York pay the most, according to the data from Statista. Physicians in Rhode Island, Pennsylvania, and New York round the top 4 states, not Florida. As a matter of fact, Florida is not even on some of the other lists, which there's Kentucky, South Carolina, Maryland, Nebraska, Oregon, Montana, Georgia, Missouri, New Hampshire, Illinois, Michigan, and Texas are the top 10 states. We've done much research on this and feel that each of you should also spend some more time in doing this research. And you cannot take away our human and constitutional rights to fix a problem. You give us back the right that every person has, and then you fix the problem. And we have many ideas, and one of the things that I wanted to make mention to is that there's a report by ACA that has a list of all the doctors in the state of Florida that has 3 or more malpractice or wrongful deaths on their records. But yet, according to your rule, the 3 strikes rule, no one should have more than 3. So I think we really need to take a look at this and ask yourself if what you're saying is accurate. Do the full research before you put a cap on something that is truly, has already been found unconstitutional, and each one of you are aware of this. So that's all I can say to this issue. I would like to make a copy of each one of this, and I'll lay it on your desk in your office as to not bother you here, to show you all of the research that we have found, and please consider it. I thank you so very much for your time and your energy. And Mr. Yarborough, even though some of the things we may not agree with you, we thank you and appreciate you. We know you've listened and heard each of our stories, and Lord Book, you as well. Each of you that have heard our stories, I mean, you cannot imagine the pain that we suffer every day. So again, I thank you and you have a wonderful day.
Thank you for being here. Sarah Franqui, and again, I apologize if I mispronounced your last name. Good afternoon, you're recognized.
Hi, how are you?
Well,
Please bear with me because it's very hard for me. My daughter died. She was 28 years old and she worked at the hospital. Her and I had gone various times to the doctors because we knew there was something wrong with her. And they kept on saying, she's okay, she's 28 years old, she's an adult. She could do, she could speak for herself. And I was there, I breastfed my daughter for 2 years. She lives with me, she helps me. I know there's something wrong. It ended up what happened was, I was on a business trip and they called me from the hospital. And she had said to me that day, Mom, my stomach is not doing well. There's something wrong. And I said, anything go, because she worked at the hospital for 8 years. She worked at ICU for 8 years in that hospital. It happened to be she got there for 4 hours. They did not do anything. They let her stay because they were trying to blame it on COVID. It happened to be that it was her fallopian tube got twisted and she needed an emergency surgery. She was pleading for her life. The doctor was a new doctor and the nurse was a new traveling nurse. They didn't know her. But her constituents who knew her for 8 years said she was pleading for her life and they did not do anything. When I went to find out what happened and to ask for accountability, why this is happening. When you go to an emergency room, what happens? You go there, why? There's an emergency. They said, you don't have a case. Our legislators in 1990 gave anybody above the age of 25 and over no recourse. I'm here, and I thank you, because you talk about insurance and the fact that our doctors, our good doctors, are paying the bulk of it. 20% to 25% of our beautiful good doctors that are doing their job well, they're paying the runt of this insurance craziness. Instead of making it legal, instead of making it possible that all doctors pay, why should only those pay? I'm sorry, I'm just so nervous. Why is it that just a certain amount? And then they claim and they complain that they're paying so much in this state.
Ms. Franklin, could you tell us what?
I approve. I want a full repeal. Anything else has been added to this bill, such as damage caps, we don't want. It's not fair that a mother or a husband or wife only gets $500,000 for the rest of their life if, God forbid, something happens to their child or their spouse. It shouldn't be. This is like a slap in the face after all of these years that this law has been into effect. So I'd rather it be Books. I'm sorry, Yarborough, but he's amazing. Because I don't want this happening to anybody else. Okay? I'm sorry. Thank you.
Thank you for being here.
Thank you.
Members, we are in debate on the amendment to the amendment. Is there debate on the amendment to the amendment? Senator Harrell.
Thank you very much, and I have to respectfully vote no on this because it really changes the intent of the amendment, the original amendment, and it eliminates the counterbalance that I think is very essential. If we are doing so much in the state to bring physicians to the state of Florida, the whole Live Healthy initiative that we are doing is really to create our workforce and to build our physician services. If we pass this amendment, we are going to eliminate the opportunity to put caps into these non-economic damages. It does not change the whole issue on wrongful death. It does nothing to touch that. So what our wonderful constituents are saying to us is not going to be changed by this. This eliminates that counterbalance that allows us to bring more physicians into the state of Florida, and people won't be scared away by the horrendous cost of medical malpractice insurance. This will eliminate those massive awards that may not be necessary. This will go, I'm sure, before the Supreme Court. It'll be litigated, I am sure. And I believe that this is the right direction to go and to make sure that we have a workforce. You do want to have care in the state of Florida. And at the rate malpractice rates are going, we're not going to have physicians come here if we don't do something to address this. So I have to respectfully vote no on this, and I hope other senators will join me.
Senator Thompson?
Thank you, Madam Chair. I'm speaking in support of this amendment to the amendment. In 2014, these caps were struck down because they did not provide equal protection. And I think that everyone has the right to stand before the law and have their case decided by a jury rather than this legislature. And in the 11 years since the caps were struck down, there is no evidence whatsoever that medical malpractice premiums went down. So this has no bearing on medical malpractice premiums. And certainly we want physicians, we want healthcare professionals in Florida, but this does not address that particular problem. And I hope we will support Senator Book's very good amendment to the amendment. Thank you, Madam Chair.
Thank you, Senator Albritton. You recognized?
Thank you, Madam Chair. So Senator Book, I think probably everybody in the room and certainly everyone on this dais knows how deeply you care about this issue and how you many times lead with your heart, and that is an incredible strength. So thank you for that. I'm going to be down on this today because, the chair has worked very hard to strike balance in this entire process. And by the way, to each of you, that's not easy. It certainly is not easy to sit here and listen to many of these stories and then have this emotional pull to get you away from the economic discussion too, because you have to have both. You can't create an environment in Florida to where there are these endless possibilities for litigation, regardless of, and please forgive me, I want you to know, please forgive me, regardless of the amount of hurt, because the problem is the greater good gets damaged and rates go incredibly high, healthcare becomes even more unaffordable, and we have a problem with doctors. We already have one now. Well, this is hard. It's hard to strike balance. Just that piece is the reason that I am not going to support this amendment to the amendment today, because I believe the chairman is on the right track, and he's looking for balance. He's trying to figure out what it looks like. That's hard, and I appreciate the work you're doing on it, but Madam Leader, I'm going to have to be down on your amendment.
Thank you. Senator Yarborough, you recognized?
Thank you, Chair. Thank you, members. Senator Book, I'll echo too what the leader just said, and some others have mentioned it too, both in speaking at the podium and on the dais. You have been looking at this issue since before I came to the Senate a year ago, and then before that, I know you had sponsored bills over here when we had taken up bills related to this in the House. And when I was a member of the House, I voted for essentially the substance of what your amendment is. In looking at the situation and the history, we, again, as I said in my opening, I don't believe we have enough support just for that, and it would take us away from the balanced approach that the leader and others have articulated. I do want to say for the record, though, that just a couple speakers mentioned it, and then Senator Thompson, you made a very good point about really going to some of the findings that I've included, and I'm not getting off of what Senator Book's amendment is, but just wanted to mention this because it came up in testimony. We do have reports that I've looked at. Belinda, I wanted to say thank you for sending what you said about Statista. I saw your email on that. I have researched, though, and found the Medical Liability Monitor Annual Rate Survey issue, October 23, Volume 48, Number 10, and also a Guy Carpenter study which performed an analysis of medical professional liability state by state. That was in November of 2023. It's about 200 pages, pretty long. Those do give rise to Florida having the highest medical malpractice insurance premiums in the nation. So in continuing to look at balance, again, taking into consideration what you said, I'm interested in any other data anyone wants to send us, but we do have reports that show that Florida is the highest in the nation, which is what, again, one of the findings is based on. Senator Thompson, you had mentioned about evidence on nothing shows that anything has changed since the caps had been put in 03. Our own Office of Insurance Regulation did a 2010 annual report, Medical Malpractice Financial Information Closed Claim Database and Rate Filings, and mentioned during 2009, 10 new medical malpractice writers entered the Florida medical malpractice insurance market. And then also, based on the analysis contained in the report, it appears that the solvency of the medical malpractice insurers was enhanced by the introduction of the '03 legislative reforms. And then page 12 of this report identifies that from 2004 to 2009, once the caps had just been put in place, we saw a 36% decrease in the insurance rates. So my respectful contention would be it did work. The reforms did work that the legislature put in '03, and then we saw an uptick come whenever the caps were struck down by our court. And again, we can get more into that in the questions back on the main amendment. But for those reasons, I must respectfully say the amendment is unfriendly. Leader Book, it's with sincerity and respect. I appreciate your work, but I can't support the amendment.
Senator Book, you're recognized to close on the amendment.
Thank you so much, Madam Chair. And I appreciate all of the commentary and back and forth because I believe this is the upper chamber and we can have incredible dialogue and we don't fear the debate. And I think that that's a wonderful piece in how we make good policy. And I know another great way we make good policy, and that's the chair, who is incredibly dedicated to this issue. And when I say to these families, again, that he knows every single one of you, he reads all of the emails, I bother him all of the time, I get it. And I know that this is a hard thing, and you're trying to thread a needle in a very difficult way. And I want to thank you for that. And I want to thank you for the love and kindness that you show these families more than anything else. I do. I just also believe that putting malpractice caps or any other hurdles in the way of any victim of malpractice isn't what we could be doing and isn't what we should be doing necessarily. I believe that these cases are already extraordinarily very difficult to bring, and there has never been any evidence that these cases are brought frivolously. These are a lot of times the worst of the worst. And I know that this Florida Senate works to our greatest good, and I believe that we can do hard things. And you're doing hard things, Mr. Chair. You're doing hard things by working through this. And so I would challenge each and every one of us to try and vote yes and find it in themselves to remove these caps and do a straight repeal free kill. Because I don't believe that this is a law that any one of us would want right on the books. But I would also challenge all of our stakeholders to continue to have this dialogue, because I am also really good at math, and I know that the likelihood that this amendment is going to pass isn't that great. But I would ask that we continue to look within ourselves. We know that the free kill law isn't what should be on the books. We've talked about that. And I know that we can do this in a different way. And so I would ask for your favorable support of this amendment, and we'll see where it goes from there.
All in favor of the amendment say yay. Yay. All opposed say nay. No. Will show that the amendment fails. We are back on the main amendment, which is barcode 932842 by Senator Yarborough. Are there any questions on the amendment? Senator Book, you're recognized.
Thank you, Madam Chair, and thank you, Mr. Chair. One of the questions that I have, and I know that the leader talked a little bit about threading a needle. And so I want to talk about why we think, or why putting these two issues together, wrongful death and caps, is the thing to do if you want to help families bring wrongful death claims, and why not have a standalone bill?
Senator Yarborough.
Sure. Thank you, Leader. Thank you, Madam Chair, and to the members of the committee. Again, what I articulated in the opening a few moments ago, and then what we just had a brief discussion on with regard to your amendment, we needed a path to bring stakeholders together, and we have those who've been engaged in this for quite a long time, those who've been personally impacted by 768-21-8, and then we have our business advocates and also our legal advocates that have been engaged as well. And as you mentioned, and thank you for your kind words, I give credit to the Lord for anything good we can do, but I'll say in trying to bring the balance together on this, it's been very difficult, but I am still open, even after this stop today, regardless of how the vote goes and how our continued negotiations go. I've expressed to each of you on the committee when I've talked to you individually, and also to our stakeholders, this is the first stop. So if there are more changes to consider and another way we can thread this needle, let me put it on the record again. I am totally open to that. I just haven't been able to find another way to do this to give justice to these families who have been wronged by the law that's been there for 34 years and find a way to get that through. So that's why the two have been put together in what's before you today.
Additional questions? Senator Thompson, you're recognized.
Thank you, Madam Chair. Senator Yarborough, how does this impact the negligent individuals? Most of the physicians, most of the healthcare professionals are very competent, very good people. And so it's a subset of people generally that are engaged in lax safety standards. And by having these caps, are we shielding these bad actors who continue essentially to engage in negligent behavior?
Senator Yarborough?
Thank you. Thank you for the question, Senator Thompson. I believe I understand the premise of your question. So I would not say that certainly the effort is not here, but I would say that there's nothing in here that would prevent our healthcare providers, our hospitals, any others who would be directly impacted from the practitioner or non-practitioner standpoint on this from still maintaining high standards of care and making sure that those who are out there on the front lines serving the individuals with need are operating with the highest standards of care. The first part of your question was how does it impact those who are affected by it? We would have the cap for non-economic damages, but again, just to make a distinction, we have no cap for economic damages, so anything related to medical bills, lost wages, and the like, those are not impacted by this, and that's not what I intend to propose at all. That's not on the table as far as I'm concerned. These are non-economic damages, which, as you and I spoke earlier today about it, it's a start point, and we can still fine-tune this and consider what the appropriate levels would be. I'm open to that, but I still believe there can be the high standard of care whenever the operation and the provision of health care takes place. The other thing, and it wasn't directly part of what you asked, but it's tied into it, again, like the court ruled twice, 2014 and 2017 on the topic, and found that we needed to abide by equal protection with regard to how this is applied. And they took exception with that with the 03 law put on the books by the legislature. This, again, is an effort to strike that balance and cure the two issues that they brought up with regard to equal protection. And if you have a claimant, if you have a single claimant, they could get $500,000, but under the prior iteration of the law, if you had 4 or 5 claimants, they were all subject to that aggregate cap. This moves to per claimant caps, so each of them have the opportunity to get up to that cap amount individually instead of in the aggregate.
Thank you.
Additional questions? Okay, seeing no, oh, I'm sorry. Senator Stewart, you recognized?
Now, I'm just trying to decide if I do the questions now or wait until the bill itself is.
There's a second opportunity. Yes, ma'am.
All right, I'll wait.
Thank you. Having said that, we have a number of public appearance cards, and we have an hour left in this committee. So what we're going to do is we're going to start out by asking everybody who has comments today, please keep your comments brief, and by brief, I mean under 2 minutes. We want to give everybody a chance, but we only have an hour, and we have many, many cards, so I'm talking too much, so we'll get started. I'm going to call 3 names. You'll be the first person up here, followed by the next 2, and I'm going to ask you to take a position in the back of the audience section here next to Sergeant Kelly to wait for your turn at the podium. So we'll start with Belinda Warren, who'll be followed by Dr. George Reinhardt, and then Dr. Paul Reinhardt. So Ms. Warren, you're recognized. If you have a brief comment, I know we've heard from you. If you have something additional that can be brief, you're recognized.
We ask first that you do not interrupt me while I read a short but not complete list of the victims that cannot be here or have never had their names said publicly.
Ms. Warren, before you get started, I am going to limit everybody's time, not just yours. So
I will. That's why I put aside what I was going to say for my family to give these names.
Okay.
Give me just one moment. Let me put on my glasses. I apologize. I'll say them as fast as I can. Helen Afram, Aaron Alicia, Thomas Antigone. Sorry if I said it wrong. Shirley Archer, Ted Osbury, Claudel Alberg, Savannah Bannerman, Stephanie Beringer, Rosemary Beardsley, Caitlin Beeson, Susan Beans, Joseph Badowski Annette Blair. Forgive.
You're doing fine.
Sorry, it's hard to know all are dead. James Blattner, Michael Blamothel, Burma Brown, Teresa Brown, Kane Thomas, Thomas Carpenter, Lynn Kosum, Bridget Castadigo, Linda Sedeno, Michael Chapman, Geraldine Cretin, Christopher Kumo, Annie Damer, Douglas Davis, Christy Davis, Matthew Dunn, Philip Dunn, Gregory Edwards, Bertha Felder, Devin Gail Ginsey, Lillian Gerber, my mother, Patricia Gaiavananzi, Cookie Grover, Becky Harper, John Hay, Christina Herberg, Elizabeth Hodge, Doreen Huffman, Pat Hughes, Jack Owens, Meg James, Taylor Jenkins, Donna Jester, Landon Jones, Bonnie Kinnard, Jimmy Krochik, Christy Lacey, Ella Lendegger, Thomas Lendardi, Angela Lincoln, Virginia Love.
Ms. Warren, we've exceeded our time limit. Please, if you could get those to everybody's office, I'm sure everybody appreciates still seeing the list.
I would be happy to give each one of you the list. Thank you very much.
Thank you for being here. Thank you. Dr. George Reinhardt, and we're going to add Dr. Charles Chase to the standing area, the waiting area back. Dr. Reinhardt, you recognized?
Yes, Chairman Yarborough, I thank you for your work, and also Senator Book for your work. I'm a potential free kill. I meet all the requirements for that. There are good doctors within the state of Florida. I had colon cancer, 2018, fully recovered. But the thing is that 49 of the states, they don't have the free kill law. And what it was required when you have a medical malpractice suit, you had to get a chief expert witness, another doctor, to testify that there's a prima facie case. And that's sufficient for 49 states. And we should eliminate the caps, because somebody that's paraplegic or a quadriplegic, $500,000 when they're this ex-actor Superman, Christopher Reeve, he was quadriplegic, and his care is more than $500,000. So there's no equity in this bill. And I agree with the amendment of Senator Book. And I thank you, Yarborough, for all your work. Thank you.
Thank you. Dr. Paul John Reinhardt will be followed by Dr. Charles Chase and then Carolyn Johnson. Dr. Reinhardt, you recognized?
The United States Supreme Court, as early as 1803, by the Chief Justice in Marbury versus Madison, said for every injury, there's to be a remedy. Like both my brother and myself are in this category. I had the honor of running for the State House of Representatives against Ralph Mazzullo, the poster child of the FMA. I ran
Excuse me,
against
sir.
him.
I'm going to ask you to please refrain from comments regarding any members of the legislature.
Okay. I ran as a Democrat, I ran as a Republican, and I ran on this free kill law, doing away with it. And the situation is that, there's a talk. Well, I entered this merry-go-round in 1990. We were talking about doctor shortages then. I attended medical school in Mexico, and I was treated by the Board of Medicine like dirt, while this legislature allowed Cuban and Nicaraguan exiles without documentation to get medical licenses, also in 1990. The solution is right in front of you. I am OPAGA. I was up here when Lawton Child signed OPAGA. I was one of the first reports on how this legislature shouldn't have licensed certain doctors then. It was a great study to do, and that's the situation. I do not agree with the OPAGA study here. What we have is a situation where you want to re-examine this, re-examine that. Don't act on a bill until we have a proper OPAGA report. This problem has been going on since 1990. They did a great job on foreign medical graduates, OPAGA. Anna Estes was the first one in charge of it. We should have all the stakeholders and these families submit evidence to OPAGA.
Dr. Reinhold, I'm sorry, but could you just
Okay.
close right this?
Okay, I actually feel that this needs to be out in the sunshine, and this should be studied. And I don't want these people leaving this time empty-handed. So somewhere along the way, get a real OPAGA report.
Thank you, Dr. Chase, followed by Carolyn Johnson, Eric Tinsman. You recognized?
Thank you, Madam Chairman. I'd also like to thank Senator Yarborough for what they call threading the needle for this issue. And thank you, fellow committee members. I'm an anesthesiologist. I'm a physician anesthesiologist representing the Florida Osteopathic Medical Association. I'm a past president of the Florida Society of Anesthesiologists, and I'm on the board of both the Florida Osteopathic Medical Association and the Florida Medical Association. There is a malpractice crisis. No matter how you look at it, Florida is up at the top in almost every statistical category of malpractice. I've worked at Winnie Palmer Hospital in Orlando, and we're the second busiest OB hospital in the nation. I have personally cut back to working 25% of what I did previously, like many other physicians, because of malpractice insurance costs. CAPS work. Prior to the installation of CAPS in the early 2000s, medical malpractice insurance for anesthesiologists in particular were going through the roof. CAPS were installed. At that point, our medical malpractice insurance started coming down. When they were overturned by the Supreme Court in Florida, once again, our medical malpractice rates started going up. Mine are almost triple of what they were before the Supreme Court's decision. That was one of the reasons why I decided to go part-time, and many other physicians have done that because of the risk of malpractice. Thank God I've never been involved in a malpractice case in any form, so I want to speak for the many physicians that are out there doing a fine job. And I also would like to say that it bothers me a bit hearing a free kill, because I think that really is disrespectful to the quality of physicians in the state. In order to be able to recruit new physicians here, we need to be able to give a adequate, fair compensation to physicians that come to Florida. When malpractice rates are that high, it's very difficult to do so. Thank you very much for your time.
Thank you. Carolyn Johnson, followed by Eric Tinsman, and Bobby Bowers will be joining us, please. Ms. Johnson, you're recognized. You just turned it off.
Did I? Okay, it's on. Thank you, Madam Chair, members of the committee. Carolyn Johnson with the Florida Chamber of Commerce. I want to thank Chair Yarborough for his thoughtfulness in trying to strike a balance with today's amendment. As our population continues to age and grow, and we're already at a shortage of medical professionals in this state, it's important that we take a look at improving our medical malpractice insurance market, and these caps do just that. We have the highest in the nation medical malpractice rates. You heard the doctor before me talk about him cutting back his own practice. And this amendment just helps address those concerns by following best practices in other states. Other states also have caps in place, like Florida did in 2003. Other states also got rid of or put in caps and saw significant progress in terms of attracting medical professionals as well as lowering of insurance rates, and we believe that will do the same here. So we ask for your support. Thank you.
Thank you. Eric Tinsman, followed by Bobby Bowers, and then Jason Goldman. Mr. Tinsman, you're recognized.
Good afternoon. Eric Tinsman on behalf of the FJA. My grandfather was a doctor. He was a small-town doctor. He was the doctor for the local high school football teams. My sister is board certified in emergency room medicine. She's a pediatrician. She runs an emergency room. I am pro-doctor, but I also believe in separation of powers. Our Supreme Court has ruled on this twice. What you are doing, respectfully, has been ruled unconstitutional twice, okay? Our founding fathers set it up that way. The courts rule, the legislators make the laws, the governor executes. You are going against something that's already been ruled unconstitutional. There are two places where every American is equal, no matter how much money they have. At the ballot box and in front of a jury. The same people you rely on to elect you are the same people in that jury box. Every election cycle, someone comes in hungry for power and overspends. They think, I can spend money and win this election, but the people go against that money. Happens every election cycle. Just because you have the most money doesn't mean you win an election. Just because you have more money doesn't mean you get to tilt the scales of justice and put caps on pain and suffering. You rely on the people for your ballot box, you need to rely on them in a jury box to figure out what the value is when a baby is switched at birth. Happens every year. To allow the jury to decide what it's worth when the wrong leg is amputated. Happens every year. We're kind of not talking about what's really going on here. Out-of-state hedge funds, private equity from California, New York, they're the reason these doctors are so busy and overworked and committing mistakes, okay? So we're gonna rely on a cap that's gonna keep that down, or are we gonna allow the jury to decide that that radiologist should not have looked at 10,000 slides the day he missed that mammogram?
Mr. Tinsman, I'm going to have to ask you to finish your comments.
I appreciate it. I'll say one more thing. I think this is an objective statement. There are three ways to deal with injured and grieving people. Our system, the best in the world. Big government bureaucracy like Europe, where the nanny state steps in and decides how much a life is worth, or Mad Max. We should keep it to this system where we trust the same ballot box and the jury box. Thank you. God bless.
Thank you. Bobby Bowers, followed by, excuse me, I'm sorry. Mr. Tinsman, we have a quick question for you. Yeah.
If I could, thank
Trying
you.
to move things here. And
Just a quick question, Madam Chair, if I could.
you recognize Senator Yarborough?
Yes, thank you.
Mr. Tinsman, just that, one of the last comments you made, and you don't have to respond now if you don't have it available, but you mentioned out-of-state hedge funds are the reason doctors might be making a lot of mistakes. We're trying to deal with a lot of data and hard facts here. Can you provide that information to my office?
Yes.
That suggests that that is true so we can review it?
You're
Yes, sir.
recognized.
I'm here all week, and we'll set up a time we can come with that data.
That sounds fine. Thank
I
you.
appreciate that question. Thank you.
Thanks for coming back up. Mr. Bowers, followed by Jason Goldman, Dr. Goldman, and then James Bounds. Mr. Bowers? Bobby Bowers, you're recognized.
Good afternoon. My name is Bobby Bowers. I am a retired homicide detective from the Jacksonville Sheriff's Office. My daughter was living a good life. She was a loving mother. She was working to become a nurse, but due to the medical malpractice, her life changed forever. She now spends most of her time in bed. She needs to be hoisted with a lift in order to get into her wheelchair. She has to have help with every single task, from brushing her teeth to eating, bathing, brushing her hair, clothing herself. Her family members now have to take care of all her personal needs. She couldn't dance to her son's wedding. She couldn't be there when her first grandchild was born. Her life was destroyed due to medical negligence, medical malpractice. Under the law you're proposing, there will be a $500,000 cap on human damages, no matter what the circumstances, for each individual. That's not what this country is about. We have a civil jury system that allows jurors to decide what is the right amount of compensation when someone is injured due to medical negligence. You want to take that away with a big government takeover that will only help the insurance industry and harm the citizens of this state. Please look at my daughter, who was once full of life. If this was your daughter, your son, your grandchild, would $500,000 suffice? Would you consider that justice, given the harm that was caused? Please do the right thing for your constituents and do the right thing for the people of Florida.
Thank you for being here. Thank you all for being here. Dr. Goldman, who'll be followed by James Bounds, and then Alexander, I believe it says Clem. Dr. Goldman, you're recognized.
Thank you, Madam Chair. Senator Chairman Yarborough, thank you for introducing this amendment. Members of the committee, I'm Dr. Jason Goldman, President of the Florida Medical Association, representing the physicians of Florida, also a general internal medicine specialist in private and solo practice for over 20 years. Having had multiple experiences dealing with patients' healthcare, both in the hospital as well as outpatient, and have great experience on the grassroots as a solo private practice physician dealing with patients every day. I want to echo many of the opening comments of Chairman Yarborough that were spot on into why this is such a good amendment, and we thank you for doing this. The issue is not only just the rising cost of medical malpractice premiums that will go up, but also the real-world access to care for our sickest, most vulnerable, and most complicated patients. The current malpractice climate is hostile for our ability to be able to take care of patients. And if we don't have caps on non-economic damages, as 31 other states do, what we see is we will not be able to get physicians to come to the state of Florida and practice. We will also see and have seen a decrease in the access to care of patients for their physicians. My own patients who have ended up in our local hospitals had to be transferred to tertiary care centers for what should have been simpler problems that could be handled in the hospital, but we had no specialists to take care of them because they're not obligated to take call, nor did they want to take call in these high-risk situations because of the lack of caps on non-economic damages and the liability risk that they face. So these patients had to be transferred to a tertiary care center, an overburdened system, not get the access to care that they need. In my own area, we do not have enough primary care physicians. We do not have enough primary care physicians in the state. You've seen the workforce data that this is decreasing. I travel nationally. I work with our National Internal Medicine, I will finish, our National Internal Medicine organization and throughout the country. We see that physicians are not coming to Florida. So I thank you for this amendment. We rise in support. Thank you.
Thank you. Ladies and gentlemen, we have approximately 45 minutes left in this committee, and I have about 45 appearance cards. This committee still needs to move into the main bill. We need to debate. We need to vote. We will run out of time. I'm going to limit everybody moving forward to 1 minute. If you have already heard what you were going to say, please take the opportunity to rise either in support or against the amendments. We're going to move forward as long as I can. There's another committee meeting after this committee meeting, so we won't have a long extension of this meeting. Having said that, I'm trying to speak quickly here so I don't take up your time. James Bounds, followed by Alexander Clem, followed by Andrew Bolin. Everybody has 1 minute at this point. Mr. Bounds, you're recognized.
Good afternoon, and thank you, members of the committee. Thank you, Chairman Yarborough and Senator Book. We appreciate your time and effort. Given the limitations, I'll only address one of my points, and that is the state of Florida has 22,610,000 residents. There are tens of millions of care events per day in this state. However, in 2023, there are only 1,295 lawsuits that were medical malpractice lawsuits. That is it. That's less than 1% of the civil cases filed in this state. Medical malpractice claims are not a crisis. They're at their lowest levels they've ever been, and that is without caps. Instituting additional caps isn't something that's needed because simply there aren't that many malpractice cases filed. Thank you.
Thank you. Alexander Clem, followed by Andrew Bolin, and then Brian Jackson. You're recognized.
Thank you, Madam Chair. Alexander Clem here. I'm from Orlando, Florida. I want to talk to you about human losses. The law calls them non-economic damages, and under the law, there are rights that are available to Floridians for diminution and loss of quality of life when you survive a medical incident, adverse medical incident. And there's also a law that provides for medical damages, especially for children, when there's a complete loss of life of a parent, and they call that loss of parental guidance, companionship. I look at this from the perspective, as we all must. If you pass a law, you've got to look at it from the perspective of 23 million Americans. When I look at it from the perspective of me, if I were sitting in your chair. My wife is by far and away the most important person in my family unit. We have 3 children. Many years ago, my children were roughly 5, 3, and 1. I think about the annual mammograms that my wife went to. And what if? She goes to the mammogram, gets it, it's clear as day to even an average radiologist is right there.
Mr. Clem, I'm sorry, but we need to go on to the next speaker at this point.
I understand.
You are against the amendment, I'm assuming.
Obviously.
Thank you. Thank you. I'm going to have to ask.
Thank you very much.
Thank you, Andrew Bolin, followed by Brian Jackson, followed by Michael Beecham. Mr. Bolin, you're recognized.
Thank you, Madam Chair. Andy Bolin on behalf of the Florida Justice Reform Institute in favor of the amendment. I want to address 2 things very quickly regarding some of the legal issues that have been brought before the committee. The first is that these caps have already been ruled unconstitutional. I want to be very clear that the caps that are on the books in the state of Florida were ruled unconstitutional because of equal protection challenges. And Senator Yarborough's bill cures those ills. It is now a per claimant cap, which addresses the concerns of the court, and it removes that aggregate cap. The other issue that I want to talk about is how these caps will actually apply from a legal perspective. First and foremost, for the most catastrophically injured plaintiffs, when there are care needs that are $45 million, $25 million, whatever the case may be, this bill does not address those whatsoever. Those can be earned dollar for dollar. The final point that I'll make is that—
Mr. Bolin, I'm sorry. I have
Yes,
to
ma'am.
call the next speaker.
Thank you.
Brian Jackson, followed by Michael Beecham, followed by Michael Williams. You're recognized.
Thank you, Chair. My name is Brian Jackson with the Texas Alliance for Patient Access, and I came here from Texas to tell you the Texas story, how our state solved a medical liability crisis with the passage of legislation that included caps. Between 1998 and 2002, our premiums for physicians rose 900%. Non-economic damages increased 500%, jury awards, in those 4 years. The environment resulted in physicians retiring or leaving Texas. Texas passed caps, and as a result of that, premiums went down 65% over the last 20 years. Physicians came back to Texas. During the time period that Texas population increased 38%, our physician numbers increased 90%. The caps resulted in more doctors coming to Texas, and I personally know Florida-born, Florida-educated doctors that are now practicing in Texas because we have a better liability environment. Thank you for allowing me to tell the Texas story.
Thank you. Michael Beecham, followed by Michael Williams, and then Karen Murillo. You're recognized.
Good afternoon. I want to introduce you to our daughter, Maddie James. She is 13 months and one of the most innocent little angels on earth. She probably reminds many of you of your own children or grandchildren, but Maddie is very different and always will be. As you can see, she's losing the fingers on her left hand. She was born with 2 healthy hands. She didn't have an accident. She was under the medical care in the hospital on a completely unrelated issue when the circulation got cut off due to medical negligence, and her hand is now going to be lost. On Christmas morning, Maddie's sister and I had to remove her thumb that was dangling from cartilage for fear that she would choke on her own finger and die. Her other fingers will fall off one by one. There isn't a day that goes by that Maddie's mother and I are not reminded of all the things Maddie will not have. She won't play basketball like her mother, or trumpet like me, or piano like her brother. She won't, when she gets married, have a finger for her loved one to put a ring on. And she will always be known as the girl with one hand to other children.
Mr. Beecham, I'm sorry, but I have to allow the next speaker to come up at this point. Thank you for being here.
I'll just say one thing. Maddie's got 100 years in her lifespan, 82 years as a Florida voter, presumably. A $500,000 cap is about a latte a day for her life. And if anyone on this board thinks that you can—
allow the next speaker to come up.
Yeah.
Michael Williams, followed by Karen Murillo. You recognized.
Thank you, Madam Chair. Michael Williams, Florida Hospital Association, General Counsel. Thank you, Chair Yarborough. We rise in support of this amendment. We appreciate all the hard work you've done on this. I just wanted to reiterate that this is an access issue as much as anything else. Caps on non-economic damages are going to improve a physician workforce in this state that has a projected shortage of 36,000 by 2035. One bullet point from Texas that Mr. Jackson didn't mention, their analysis of their non-economic damage law showed that they put in, over the 20 years after the law was passed, 18,000 extra physicians over their expected baseline. That would cut our shortage in half. Reason for that? According to our OIR, family practitioners in Florida and Miami-Dade County, which is the highest in the country, $52,000 premium. In Texas, their highest county, $9,185. ER doc, $112,000 in Miami-Dade County. Texas, $16,074.
Thank you, Mr. Williams.
Thank you.
Karen Murillo, followed by Tony Yates, who's going to be followed by Sarah Franqui. You're recognized.
Thank you, Madam Chair. Karen Murillo on behalf of AARP. Mr. Chair, I want to bring up unintended consequences of this amendment for your attention. We applaud you for the wrongful death work that the exceptions that you're working on, but this is going to disproportionately impact older adults, especially older vulnerable adults. Lines 14 through 25 of your amendment include references to nursing facilities as well as assisted living facilities. And the non-economic caps are going to disproportionately impact those seniors, those older adults. Their recovery for economic damages is already significantly limited due to no loss of wages in most cases and due to their reliance on Medicaid and Medicare. Non-economic damages are all that they can rely upon. So this is going to impact them most critically. And for that reason, we are asking that the committee vote no on this particular amendment. Thank you.
Thank you, Tony Yates, followed by Sarah Franqui, followed by Robert Arrington. Good afternoon, you're recognized.
Thank you. My name is Tony Yates, and I'm from Pensacola, Florida. My wife and I were married for 25 years, and we have 4 beautiful children. Due to medical negligence, we lost my wife. The thought of politicians putting a value on my wife's life is unbelievable to me. The folks in this room are not the right people for that. We hire jurors across this country every day, and they listen for weeks and weeks like they did in my trial to details in a very personable level. These are the people that need to put the number on the life. They say that time stops the pain. Well, I don't think that's the case. Just this past week, our youngest daughter, Amber, sent me pictures of her putting new flowers on her mother's grave. In that picture is her quilt. And I wish I could say there was a lot of tears of joy and happiness in that quilt, but there's a lot of tears of pain. I pray that all of you will not have to experience the heavy, deep loss that my family has experienced.
Thank you, Mr. Yates. Thank you for being here. Sarah Franqui, followed by Robert Arrington, and then Stephen Watkins, you're recognized.
Hi, how are you? We continue to talk about doctors in the state and why they're leaving. My brother-in-law was a doctor, and when he did get COVID, they left the mask on so bad that it eroded in his nose, and he couldn't bear to think that his constituents let that happen to him. Many doctors leave the state because of this law, because insurance companies are making it difficult for their patients, for them to see their patients and to take care of them the way they are. And they analyze and they say, we are going to be the next victim of this law. We have to stop. Many of them come and they stay here and they realize they have to go because this state is not helping their families as well. So you don't realize how this law has impacted our good doctors and why they left. Because many of them do stay here and pay the bills because they love this state. Our governor said, we are proud to support life and family in the state of Florida.
Thank you for being here.
Thank you.
Robert Arrington, followed by, I'll give you a minute, Mr. Arrington, to get there. Take your time. You're recognized, sir.
Good afternoon, legislators. My name is Robert Arrington. I'm a military veteran and a citizen of Leon County. I am thankful to be speaking here today, but I shouldn't be. What started as a routine knee procedure that many of you may have soon turned into a fight for my life because of healthcare professionals failed in their most basic of duties. The very people who hold their lives in their hands when they're most vulnerable nearly cost mine. But after 3 painful, grueling years, it did lead to the amputation of my left leg above the knee. Along with losing my limb, I now look forward to a future plagued with hip, back, and neck problems. But this could easily be anybody here in this room or you. When victims of medical malpractice are killed or permanently and fundamentally changed, how can you put a limit on what it takes to put those lives back together, especially since they broke those lives, especially when the lives are as varied as a neglect that changed their lives forever? If you can trust a jury to render a verdict, then why would the trust stop there? Lastly, let us not forget we're the victims, not the insurance companies. We didn't ask for these injuries. We trusted a hospital to keep us safe, just as we trust you legislators to govern fairly with justice. And while jurors can render justice, a cap has never held anyone accountable. Thank you.
Thank you very much, Mr. Arrington. Mr. Watkins, Stephen Watkins, followed by Philip Gold, followed by Jose Medines, I think, but I may have mispronounced that. And Mr. Watkins, you recognize?
Hi, my name is Stephen Watkins. I work for Flagler County Sheriff's Office. I have for 13 years. I started at corrections. I'm now a dispatcher because I'm paraplegic, had a staph infection. I was going to go one way with what I was speaking, but listening to everybody, all the reason why you're for this is because it's going to help the insurance malpractice, so it's cheap, it's better for the doctors. However, 8 years ago, I didn't need any medical supplies. Well, now I do, and those medical supplies are constantly increasing. So why does it that? Because their malpractice insurance is more important than my medical supplies increasing each year. And I get it that you want to bring doctors to this, but they also have to have accountability for themselves as well. If they make a mistake, if they do something wrong, that's on them. If I had nothing to do with where I'm from, mine was a staph infection, it was a disease. So only thing I want you guys to think about is why is one more important than the other? Thank you.
Thank you. Stephen Gold, I believe, right? Where am I? Oh, I'm sorry. I was reading 2 cards at the same time. Phil Gold, you're recognized.
Thank you, Chair. I'm a medical malpractice practitioner for 17 years. I've testified before you all last year, the year before. There's a difference between economic and non-economic damages, as Bill's sponsor makes very clear. But the way it plays out is that medical expenses that come to our clients go back into the system. They get money to have care in the future, and then when they receive that care, the money that they're receiving goes back to the medical provider or to big pharma for having pain meds. It's only the non-economic damages that compensate the victim personally, right? It's not non-economic damages, they're defined. It's disability, it's impairment, it's deformity. Those are the elements of damages that you will be voting to limit to $500,000.
Thank you, Mr.
When a
Gold.
bovie burns half
Mr.
your
Gold,
face.
Mr. Gold, I have to call the next speaker. Thank you for being here, though. Jose, and I apologize, Mejenes, followed by Chris Newland, followed by Steve Asencia, and please pronounce your name for me, sir.
Sure, thank you. My name is Jose Miguenes. I traveled here from Miami today on behalf of my son Bradley, who's 4 years old. Bradley was a victim of medical malpractice and suffered brain damage. He now lives as a quadriplegic with cerebral palsy, epilepsy, vision impairment. As a father, it's hard to cope with all the things that you want to do with your kid. Throwing a football, throwing a baseball. There's a lot of things that create that quality of life, that happiness. To put a cap on that is taking away his dignity, taking away his value on what he can do, on how he can be a part of this community. Bradley can't sit, he can't stand, he can't talk, he can't speak up for himself here, okay? Gets fed through a G-tube, all right? You all talk about balance here. The balance that we have at home is very different, okay? As a parent with a kid with special needs who's gonna be fully dependent for the rest of their life, putting a price on what that looks like, on what that quality of life looks like, is detrimental, not only to my son, but to everybody else in his position.
Thank you.
Thank you.
Chris Newland, followed by Steve Asencia. Chris Newland, Mr. Newland, you're recognized.
Thank you very much, Madam Chair. Thank you, Chair Yarborough, for, as you mentioned,
threading the needle. This is not, in its original form, a free kill bill. There are ramifications for the doctors. There are compensation that are awarded, the actual economic damages currently. But we understand that there is a problem that this bill wants to address. But that will raise malpractice premiums by placing a reasonable cap on non-economic damages, not just the medical, the economic, the non-economic damages. We strike a balance. This is a tough job, senators, and thank you, Chair Yarborough, for recognizing that and coming up with a balanced solution. Thank you. We support the amendment.
Steve Essentia. HCA waives in support. Adam Bassford. Is Adam here? Associated Industries of Florida waives in support. Gary Guzzo. Florida Insurance waives in support. Thank you. Steve Wynn. Florida Osteopathic Medical Association waives in support. Beth Young. Is Ms. Young here? Waives against. Katie Webb. APCIA waives in support. Thank you, Katie Webb. Fraser Cobb, Duval County Medical Society, waive in support. Megan Sowell. Is Megan here? Megan, followed by Robert Travieso, and then Tim Graves. Thank you for being here. You're recognized.
Thank you, Madam Chair. I just wanted to start off by saying thank you for being able to hear me. I'm a medical malpractice attorney from Jacksonville, Florida. When I started my legal career, I was a prosecutor. I had the privilege of representing the people of the state of Florida. We had a motto, pursue justice always, and I just want to stress the committee, this does not pursue justice. If you apply it to a criminal application, to put a cap on a homicide case at 10 years in prison is not just. And if we're not going to do that when someone's been harmed by our community in the criminal side of things, we certainly should not be doing that in the civil side. To put a price on a death of a 3-year-old girl at $500,000 is shocking. To put a price on a 49-year-long marriage where the wife died as a result of medical negligence is shocking. And to put a price on a stay-at-home mother who's there not only taking care of the home, but supporting her children, being there, being a loving wife, being a loving mom. I'm the product of a stay-at-home mom, is shocking and it's wrong. And I encourage all of you to pursue justice.
Thank you. Robert Travieso, followed by Tim Graves or Groves. You're recognized.
Good afternoon. My name is Robert Travieso. I'm a lawyer. I represent the victims of medical malpractice in Ponte Vedra, Florida, and throughout the state. I'd like to draw the committee's attention to who exactly will be harmed by this amendment. We are not, as Senator Book astutely pointed out, we are not dealing with frivolous lawsuits in this instance. Each and every medical malpractice claim that is filed has gone through a pre-suit validation process. It requires an expert healthcare provider's sworn statement that there are grounds to pursue a claim for malpractice. That case then has to go to trial, where a jury of the plaintiff's peers then determines that the doctor committed malpractice. They don't even reach the decision or the question of whether what the damages are going to be until they've decided that malpractice was committed. And then is when they make their decision of what the facts and circumstances of that case justify in terms of damage.
Travieso,
Thank you.
Tim Grover. Is it Grover? Tim, you'll tell me what your last name is. I apologize. Landon Stinson, followed by Todd Michaels. You recognize, sir.
Good afternoon. Tim Groves. I worked as a defense attorney for 6 years, the first 6 years of my career before switching over to representing victims in last October. As part of that process, we worked tirelessly with the adjusters to minimize the value of these claims. An unintended consequence of these caps would only overburden our judicial system more so than it already is. In the role as the defense, we would use the caps under the voluntary arbitration proceeding at the end of pre-suit, which caps the human damages at $250,000. That was not the end point. That would be the starting point for negotiations, with our position being that's the worst we would ever have to pay, so why would we pay that to start with? A $500,000 cap would likewise embolden insurance adjusters and defense attorneys across the state to say, why would we pay $500,000 to start? we would require you to go to trial to get that amount. So it would increase the burden on trial judges and juries across the state, as it would increase the amount of medical malpractice trials that go to trial. Thank you so much for your time. I appreciate it.
Thank you, Mr. Groves. Landon Stinson, followed by Todd Michaels, and then Waylon Thompson.
Good afternoon. My name is Landon Stinson. I'm a Christian, a father, and a husband from the great city of Gainesville, Florida. You all have a very difficult, stressful job, and I appreciate everything that you do. I'm going to share my point of view with a story. Imagine that you're on vacation in England and you're the victim of a horrible medical malpractice event. Do you have the right to a trial by jury? You do not. And that's because the American civil jury trial is one of the most American things that we have, is that when you're hurt by a doctor, 6 people from your county get to decide how much that's worth. And this amendment would put this legislature as the 7th juror on every medical malpractice case in Florida. I believe that's wrong. I appreciate your time. Thank you.
Thank you for being here. Todd Michaels. Waves in opposition. Thank you, Mr. Michaels. Waylon Thompson. Mr. Thompson here. Good afternoon. You're recognized.
Thank you, Ms. Chair. Thank you, committee members. I'm Waylon Thompson from Panama City. As we've heard, the Florida Supreme Court declared these caps unconstitutional on 2 different bases. One is it treated people unequally, unfairly. Number 2, the numbers were arbitrary. So why are we here today in 2024 talking about it again? Well, the purported vehicle is to right an injustice that everybody here says acknowledges exists, right? So how are we doing that? Then we're trying to do that by, again, limiting the amount and treating people unfairly. Why do I say that? Well, if you're a Medicaid recipient, guess what? Your number is limited to $300,000. We haven't heard about that today. All others, it's $500,000. So a half justice is no justice at all. So are we going to tell the poor people of our state that you're not worth what other people are worth? This is a bad amendment. We need to, excuse me, have the amendment stricken, as Senator Book had suggested, and have a vote straight up on eliminating the exemption.
Thank you. Senators, under Rule 2.10, Paren 2, the President has authorized a continuation of this meeting until 3:45. We are now in debate on the amendment. Is there debate on the amendment? See no debate on the amendment. Senator Yarborough, you recognize to close on the amendment.
Thank you, Madam Chair. I did want to say thank you to those who have spoken on the amendment. I know we still have to get back on the bill as amended, but I did want to ask the committee to support this. I was making some detailed notes while some of the speakers were talking, and we had spoken about it earlier when we had the amendment by Senator Book, and then also I mentioned it in my opening about the challenge that what we're doing now may be unconstitutional, but again, we have cured what the concerns were that were addressed by the court. I heard Mr. Thompson, I believe, just say that the caps are arbitrary. I think the real problem with the intangible and unpredictable nature of economic damages, is tied to the fact that it's very difficult for juries to determine an appropriate award of those. The very nature of pain and suffering renders it incapable of measurement without speculation and guesswork. So it is very hard to do this, and that's why I've said, Mr. Thompson, I'm not sure where you went, but we spoke earlier. Thank you, Mr. Kane. I see you're here. I'm still open to ideas. I mean, when we met in my office over the past couple of weeks, just like I said earlier today, if there's a different way to thread this needle and not continue the injustice on the books for those impacted by 768-21-8, and this is to everyone here and everybody watching, I am open to ideas. But whenever I put that out there over the past couple of weeks, and even since October when I filed the bill, there's nothing else that I have in front of me to find the balance. So I'm still willing to work with everyone. Again, that wasn't just pointed at 1 or 2 speakers. We need to find a balance with this. It needs to be the right product. So I get what we're dealing with here. But this is the first stop for the Senate. We still have to negotiate with the House. I believe there's an openness for all sides to find balance on this. And I know among our legislative partners there is as well. So bring the ideas. Let's continue to work on that. This bill is about promoting justice. I disagree with what one speaker said. If we leave 768-21-8 on the books, there's going into a 34th year of more injustice. So we have to find a way to fix it. Madam Chair, with that, I would close and ask for your support.
Thank you. All in favor of the amendment, say yay.
Yay.
Opposed, nay. We'll show the amendment is adopted. Excuse me. Are there further questions on the bill? Now we're back on the bill as amended. Any further questions? Seeing no questions? Senator Stewart, we're good? Okay. We do have some appearance cards on the bill. Some of you may have spoken on the amendment already. Feel free to waive in opposition or support because we have a little bit more time, but we still don't have a lot of time because we have to have debate and we actually have another bill in front of this committee. So Dr. Charles Chase will be followed by Stephen Kane and then Jason Goldman. I know I've said a couple of those names before. You recognize this, sir? Dr. Chase, waves of support. Thank you. Stephen Kane, good afternoon. You're recognized. 1 minute.
Chairman Yarborough, thank you for getting the sides together and discussing this issue. I know you say you're interested in threading a needle, but the thread's not getting through this needle. You've seen the victims. You've seen the folks, the little girl with her fingers falling off, they're dead. You've seen the folks coming up in wheelchairs missing a limb. $500,000 is not justice. We have a system of justice in this country. We have our Constitution that I know each of you hold dear to your hearts. And the thing that we have under that Constitution is the 7th Amendment right to a jury trial that lets the people decide what a claim is worth. We've heard, I just heard, and I'm struggling with it, that one of the doctors here has seen his insurance rates triple. All the data we have, it's gone up 6% since 2004. Maybe we need to get the insurance company. We need to be looking at the insurance companies. We need to be looking at the hospital corporations and their profits.
Mr. Kane, thank you.
Because they're not going back to the
The next
doctor.
speaker's coming, and that would be Jason Goldman. Mr. Waves and support. Andrew Bolin. Andrew Bolin, Florida Justice Reform Institute, waves and support. Brian Jackson. Same organization, waves and support. Lorette Phillipson, followed by Tamika Ganzi, and followed by Alyssa Crocker. Good afternoon. You're recognized, ma'am.
Good afternoon. Thank you. My name is Lorette Phillipson. I'm a resident of Pasco County. I wanted to provide you all a face today. My daughter, Heather. Heather passed away 15 years ago this month, a death that never should have happened, as I begged 4 different physicians to perform or write a script for a lumbar puncture to check the spinal fluid pressure. When this was finally done, Heather's pressure was more than twice the normal amount. She was placed on a medication to help relieve the pressure of her brain, which on day 5, she had dual strokes to the occipital lobes. Heather was now blind. For the next 1.5 years, my daughter remained in a hospital fighting for her life. I hope that not one of you have to stand and watch physicians and a medical team, not once, but 7 times, assist your daughter during a cardiac arrest. And this is all because of medical malpractice, not by 1 doctor, not by 2 doctors, 4 physicians in the state of Florida. I had one physician tell me, "You're not an MD, you don't have it after your name, you don't know what you're talking about." I was 100% correct.
Ms. Phillipson, I hate to cut you off, but we have
I
limited
usually
time.
speak before the criminal justice committees in the House and the Senate, and I hear all of you talk about
Ms.
making
Phillipson, I'm
people
sorry, but I have
accountable.
to allow the next
I'm
speaker.
asking you to make physicians accountable.
Thank you. Tamika Ganzi, followed by Elisa Crocker.
Hello, everyone.
You're recognized.
Senator Yarborough, thank you so much for sponsoring this bill to help the families of people who have passed away due to medical malpractice. I appreciate that. I flew in from New York City just for this meeting today. I was the 5th one through the door. I've been here for 4 hours before the meeting to make sure I got a chance to speak. Not sure how I got to the back, but I'm here. In the next 11 to 14 months, God willing, I intend on being a provider. I anticipate to treat all of my patients the way that I should treat them and to do no harm to them. I understand that sometimes things happen. However, I expect to be held accountable if I do something egregious that takes someone's life. What I'm asking you to do is just to hold individuals accountable who make egregious acts against what they're supposed to do. Think about the patients who die. Please, thank you so much.
Thank you for being here. Elisa Crocker, followed by Michael Williams, and then Philip Gold. Good afternoon, you're recognized.
Good afternoon. Just want to start by thanking Senator Yarborough. This bill means a lot to me. My father, Derek Crocker, passed away in 2022 due to medical negligence in a hospital in Miami. There was nothing I could do about it because I was over the age of 25. So really anything that goes to help with that is a step in the right direction. And I understand that, you know, you can't put a limit on something, but sometimes something is better than nothing. So I agree with what you're doing, because without it, there'd be a lot of people who couldn't do anything at all.
Thank you for being here. Michael Williams. Waves in support. Philip Gold, followed by Marcia Shepler, and then Beth Young. You recognize Mr. Gold?
Thank you very much, Chair. The data from OIR reporting in October of 2023 made it clear that the medical malpractice insurance carrier profits are doing well, and they have been doing well. That's from our Office of Insurance Regulation, published in their last publication. So why are rates a problem, and why are rates going up if the insurance carrier's profits are doing well? Ask yourself that question. You asked for other ways to thread the needle. If we required all of our physicians in this state to obtain insurance, the data shows that that would have the most dramatic decrease on insurance rates. Insurance is a group understanding. We're all in it together. Why have the good doctors that pay into insurance be punished by the bad doctors who choose to save that money for their own pocketbook instead of paying into our insurance system?
Thank you. Marcia Shepler, followed by Beth Young, and then Sabrina Davis. Good afternoon, you're recognized.
Thank you. My name is Marcy Shepler, and I am JoJo's mom. I took my son JoJo, who had Down syndrome and autism. He was nonverbal, and he had cognitive level of a 2-year-old, to a ER, and he was refused treatment. I took him to another hospital, and he was found to be in septic shock, and he passed away, and he was 29 years old. The ACA CMS found against the hospital and sanctioned them with creating a condition of imminent jeopardy. I was his guardian advocate. JoJo's all his adult rights were stripped away when he was 18 because he was incompetent. And as his mother and guardian advocate, I could have been held criminally liable for criminal neglect if I had not sought medical care for him, yet I was not deemed enough of a parent to be able to pursue justice for JoJo under this law. So the subsection 8 is wholly discriminatory against people with developmental disabilities. It
Ms.
needs to be
Shepler.
repealed.
Thank you
For bringing the bill.
Thank you for being here. Senator Boyd, you're recognized, yes, sir.
Thank you, Madam Chair. I move that a vote on SB 248 be taken at 3:40 p.m. today.
A motion for a time certain vote at 3:40 p.m. has been made. Is there any objection? Seeing none, show that the vote on Senate Bill 248 will be at 3:40 p.m. We're back to our appearances. We have Beth Young, followed by Sabrina Davis, followed by Ann Cuomo-Neri, and you recognize.
All right, my name is Beth Young, and thank you for letting us talk on the statute 768.21, subsection 8. My mom was 66 years old, and we live in Tallahassee, Florida. She went to Tallahassee Memorial Hospital to get a Watchman procedure to help with the AFib. There were many red flags that I've seen. As a CNA, it may not be a doctor, but as a CNA, I see red flags, and I know what's right and what's wrong. And she didn't deserve to have a brain hemorrhage and pass away on the 18th, from August 8th to the 18th, until she passed. and she shouldn't have been gone. She was an RN nurse, and she was very valued to each and every person that, knew her. And just like every one of your families, they all deserve value. It shouldn't matter, rich or poor. It shouldn't matter. And just to let you know about this, we have petitions, just to let you know that there's
Ms.
about...
Thank you, Ms. Davis, for being here.
Thank you.
I'm sorry, Ms. Young. You're Ms. Young. Beth Young, correct? Okay, thank you. I'm on to my next card. Sabrina Davis, followed by Ann Colmoneri, and then Kevin Christopher Buffard. You are recognized.
Thank you, Senator Yarborough, for bringing this bill. My dad, Keith Davis, was a Navy veteran of the United States Navy. He went to a hospital for knee pain, and 5 days later, he was dead. The doctor refused to order an autopsy, so I did, and it revealed that my father died of a 9-inch long blood clot. This was not a lack of knowledge, but a disregard for my father's life. God gave me one dad, and he was my voice of reason. We had so many plans, and that was all taken from me, and I will have to live with the results of this reckless behavior for the rest of my life. The Department of Health determined medical malpractice was committed via case number 2023-4303. I refuse to lose sight of my prime focus. I do not want anyone else to be asked if they were single, divorced, or widowed and how old their children are and able to have access to the courts. You cannot compare a small stack of medical malpractice premium rates to the price that my father paid for this country. Today, I am asking for justice to be restored and not justice to be reformed.
Thank you, Ann. Thank you for being here. Ann Cuomo-Neri, followed by Kevin Christopher Buffard. You're recognized.
Thank you. My son, Christopher Cuomo, consented for a 2.5-hour laparoscopy to repair a hernia after he was under general anesthesia. His general surgeon decided to perform an open surgery that lasted for 9 hours. My son suffered for 23 days in medically induced coma and on a ventilator. Christopher went into organ failure and was taken off life support March 18th, 2022, and passed at 1:25 p.m. He was healthy. He worked the full day before he walked in with me that morning. My son should have been home that afternoon. My son is not his surgeon's first, second, or even third casualty. She is a menace to the medical community. Dr. Maria Castilla of Port Charlotte ripped my son's life right out from under him. Falling into this category of being over 25 single and no dependent children is discriminatory and unconstitutional. I should be able to hold this monster responsible. Instead of focusing on scaring away doctors from coming to Florida because of high malpractice premiums, the state of Florida should not welcome second and third-rate incompetent doctors. Thank you.
Podium, Kevin Christopher Buffard, followed by Janie Black, and then Judy Buhay. Good afternoon. You're recognized, sir.
Thank you. I lost my brother. That was Christopher Cuomo. Also, that was his story. I've been broken ever since. This free kill law is not only unfair, but it is also blatant disregard for the value of human life and the rights of our citizens. In a state that prides itself on its commitment to justice and equality, this law is an egregious and glaring contradiction. It is a relic of the past, and it is time to take action and bring Florida's laws into the 21st century. As we look into the future, we must ask ourselves, what kind of society do we want to be? Do we want to be a state that turns a blind eye to the suffering of its citizens, or do we want to be a state that stands up for the rights of its people, regardless of age or marital status? The answer is clear. It is time for us to repeal Florida's free kill law and replace it with a more just and equitable system, a system that recognizes the inherent value of every human life and provides equal protection under the law. The time for the change is now, and the responsibility lies with us. Also, it is vital that we amend the current bill to enable family members of lost loved ones before July 1st, 2024.
I'm sorry, but you have to allow the next speaker to come up now. Ms. Black, Janie Black, followed by Judy Buhay. Good afternoon, you're recognized.
Good afternoon to you all. The reason we're here, and we have to understand that this law must go. My son was taken away from me on May 23rd, 2021, when hospital doors was locked. families could not get to their loved ones. When I got to my son, instead of me going to the emergency room, I was asked to come to the conference room on the 3rd floor. At that time, I learned my son was dead within 5 hours of me dropping him off. I recognized something was very wrong, very wrong. The questions that I asked those doctors, what happened to him, I could not get the answer that was satisfactory to a sudden death. Yes, I would like
Sorry.
to say, yeah.
Thank you for being here.
Okay, and if I could just.
Ma'am, I'm sorry. We have a time certain on the vote. I appreciate you coming today,
This
though.
law needs to go.
Thank you for being here. Yeah. Judy Buhay, I believe, you're
Yes.
recognized.
Thank you. My beloved son, Colin Hepker, is going to be 25 in 4 days for the rest of his life. He lived a successful, financially independent life in Denver. I was in Orlando visiting our family. He passed away a few days after returning to Denver. There was absolutely no travel restrictions, and they gave him nothing for his lungs, and he died of acute respiratory distress syndrome. I've researched it enough, talked to experts that review the charts, and people don't die at home from acute respiratory distress syndrome. I will never forget the feeling of having a deputy contact me and tell me my son is dead in bed after I did a welfare check. I am against this age of 25. It's so arbitrary. 25 in 4 days is ridiculous, that he was 4 days or 5 days beyond the limit. I also want to say that I would challenge anybody, any of these med mal lawyers, to look at how many people can't file or how many cases will you not take because of limits? I have a friend in Texas,
Ma'am.
$250,000, nobody would take it. Thank you.
Thanks for coming. Folks, I'm going to read the rest of these into the record so that we have time for members to debate this. This bill is amended. Karen Murillo with AARP is waiving against. Gary Guzzo, Florida Insurance Council, waiving in support. Steve Wynn, Florida Osteopathic Medical Association, is waiving in support. Todd Michaels, he is here against. And Robert Arrington is also here against. Members, we are now in, and I want to thank everybody for coming, and limited time, I apologize, we didn't have more time for everybody. We're now in debate on this bill as amended, or do we have debate? Senator Stewart, you're recognized.
Thank you, Madam Chair, and I did have my questions addressed during the discussion. I'd like to thank Senator Yarborough for bringing this bill to us. I know this has been a complicated subject to work on. I feel that I'm looking forward to the senators' continued discussion with stakeholders and the senators on this matter. I know he's had an open door. I've had numerous discussions with him. I want to thank you for having that with all of us. I expect changes at the next stop due to the public testimony today, and it was very passionate, and we do understand each and individual differences, but we have got to move forward with this bill, and I'm going to be supporting it today.
Thank you, Senator DeSigley. You're recognized.
Thank you, Madam Chair. I want to first start by thanking Senator Yarborough for your time on this bill, not only with me, but with all the stakeholders, all of the other members of this committee. For me personally, the easy part of this bill is the repeal of the Wrongful Death Act. I think that's something that I supported when I was in the House a few years ago. That to me is a no-brainer. What I'm having a difficult time with, and I shared this with you, Senator Yarborough, is putting a cap on some of this, medical malpractice, non-economic claims. And we've heard the reasons. We heard a lot of folks, speak about their experiences today. And I'm going to support this bill today because I'm confident that you're going to continue the conversations with the stakeholders, obviously with all of us on this committee and our colleagues in future committee stops moving forward. So, again, there are two parts of this bill. One for me is really easy. The other one it's just I'm having a difficult time getting there. But in order to and I do greatly respect you and the work you've done, I'm going to be up on the bill today. Thank you.
Thank you. Senator Harrell, you're recognized.
Thank you very much, and thank you, Senator Yarborough, for working with me and having many conversations with me. And I want to say thank you to all the people who did come and speak. We have heard you, we feel your pain. I think that in addition to that, I think that the aspect of the caps is essential in order to move this bill forward. I think it strikes that balance that is necessary. And I want to remind everybody that these caps are not relative to economic damages. We've heard so many people with various difficulties. This does not impact that. It does not impact economic damages. And as far as going before the Supreme Court and this being challenges, it removes the major aspect of why this was overturned. So I think this meets all the necessary prerequisites in order to continue to be in law, and that will stand the test of the court. So with that, I'm going to support this bill today, and I would advise my compatriots to please do so also. This is the balance we need to move this legislation forward.
Thank you, Senator Albritton. You recognized.
Thank you, Madam Chair. A couple of things I want to address very quickly. First of all, I heard the term balance of power. Well, I want to tell everybody here, I want to make sure that I'm being very clear. The court system is not the highest level of state government. They share that distinction with the legislature and the executive branch. That's what balance of power means. We are not just free to have our own opinions as elected individuals here, we're actually required to do so. The Florida legislative voice matters. The second thing that I want to say is that I heard today medical malpractice insurance rates, one says doubled, one says 6%. I remember a statistics class I took in college, and there's a lot of ways that you can spin these numbers. Now, is that in $2003? Is that in $2024? Are we talking about apples and oranges, or maybe just different varieties of fruit? I don't know, but that doesn't make any sense. It's incredible, unuseful testimony, in my opinion. The idea of insurance companies' rates going up while at the same time, these medical malpractice rates, their profits go up and these rates are going up at the same time, that's disingenuous. Everybody here knows, likely, most of you know, that is a process derived from the Office of Insurance Regulation. And insurance companies are heavily regulated on the kind of profits they can generate. There's a rate case process that they go through. I felt that to be a bit disingenuous. What I can say is I do believe that everybody on this committee has heard each of you very clearly, and this free kill law needs to go. For each of you here that have shared a loss, I want you to know you don't know me from Adam. But I want you to know as sincerely as I can derive it for you, I'm sorry for your loss. I also know this. I know that the chairman has taken this bull by the horns, and he's done a very good job with it to strike fairness. That's a relative term, but you've been pursuing fairness in this, and I encourage you to keep doing so. Maybe there's some part that doesn't need a cap. Maybe the caps are low in some places. Maybe they aren't in others. But at the end of the day, hard issues require hard choices. We're making hard choices here today. This isn't easy. I'm certainly not saying what you've been through is easy, but I can tell you when we're trying to find fairness, it's not easy because fairness lies somewhere in the middle, somewhere in the middle ground. And it always includes everybody, not just a small segment, but everyone who pays insurance rates, and families are impacted by what health care rates and the cost of insurance are here in Florida. It's an ongoing challenge that we need to be working on. I don't have any expectation that advocates would advocate against themselves. I don't. But I would remind everybody that is advocating for or against this that your input matters. And you want to be in the room, and the chairman's giving you that opportunity. And lastly, I would say, this decision lies with us. The Florida legislature is going to make the decision on what fairness means. I have every ounce of faith in this chairman. And I thank you for the work that you're doing. This bill solves a problem. This free kill needs to go.
Senator Thompson, you're recognized.
Thank you, Madam Chair. And thank you, Senator Yarborough, for your visit with me and all of the work that you've done on this legislation. I will not be able to support it today because I strongly believe in the constitutional right of Floridians for full legal redress, and that means going to court and having a jury decide what's appropriate with regard to pain and suffering. One size does not fit all. To have a person injured through medical negligence who has to live, let's say, 20, 30 years and will need equipment and supplies and so many other things is not the same as maybe someone who has less time to have to endure those kinds of things. So I don't think that the cap is the thing that we need to be working on. And I do appreciate your assurance that you are open to continued conversation and to get to a point where we are not denying legal redress to Floridians. I won't be supporting it today, but I appreciate all of your work. Thank you.
Senator Yarborough, you recognize to close on the bill as amended.
Thank you, Madam Chair. I appreciate the members of the committee. Thank you for those who have asked questions and participated in debate. Thank you. And I think most of the important points have been said, Madam Chair and committee. I would just say that to Senator Alberton's point, and we laid this out in the findings that are a part of the amendment and the whereas clauses, we can't know with 100% certainty how courts will respond to the bill. But in one of the cases related to upholding caps on damages, I believe it was University of Miami versus Ashart, if I have that name right, the Florida Supreme Court did acknowledge that, quote, the legislature has the final word on declarations on public policy, and the courts are bound to give great weight to legislative determinations of facts. Further, legislative determinations of public purpose and facts are presumed correct and entitled to deference unless clearly erroneous, which we've talked about today. Because the legislature's factual and policy findings are presumed correct, and there's been no showing that the findings in the instant case are clearly erroneous, we hold that the legislature has shown an overpowering public necessity exists. And then lastly, again, with regard to the constitutional aspect, state and federal courts around the country have addressed the issue, and many have determined that the caps are constitutional and rationally related to the important state interest of bringing down the cost of medical malpractice insurance and facilitating the availability of affordable health care. We have 31 or 32 states that have caps on non-economic damages, or maybe even caps on economic damages. There are only 8 of those that are $1 million or north. So if we were to enact these caps, we would be well among our peers to go about this and to try to strike the balance that we're trying to do today. Madam Chairman, that said, I appreciate the comments of the senators, ask for your support, and I very much look forward to more input so we can make it an even better product moving forward.
Lisa, please call the roll on CS for Senate Bill 248.
Senator Albritton. Senator Book. Senator Boyd. Senator Broxton. Senator DeSigley. Senator Harrell. Senator Stewart. Senator Thompson. Senator Yarborough.
Yes.
Chair Burton.
Yes.
8 yeas, 2 nays.
By your vote, CS for SB 248 is reported favorably. Chair?
Thank you, Madam Vice Chair. I appreciate you taking the reins while we took that up. Members, we do have one other bill under tab 4, Senate Bill 910, related to public records, veterans treatment, mental health court